Hello, I am Professor Robert Linz, a law librarian at the University of Colorado Law Library in Boulder, Colorado. This is the first presentation in a series of presentations introducing researchers to the process of legal research. In this particular presentation, we'll cover the concept of authority and the different types of authority and how that applies to our process of legal research. We'll also talk about some themes in legal research publication that I think will simplify your research and make you more confident researchers. So what is legal research? Well, it's very simple. It's actually just the process of finding legal authority to resolve a legal problem. So we're finished as researchers when we find all of that legal authority and we can confidently say what the answer is to the issue that we're trying to do research. But there's a little bit more to it than that. Legal research is really an analytical process. To do it well and to do it properly, you need to be able to identify significant facts in the problem that's given to you. You need to identify the legal issues and the problems that are presented by those legal issues. And then we have to be able to locate, evaluate, and manipulate research authorities. That is to say, we need to find the case law, or the statutory law, or the regulatory law that helps us answer our legal questions. So, effective analysis involves an understanding of the organization and rules of the legal system, the resources that contain those rules, and how to use those resources efficiently and effectively. Once all of that is done, you can then develop and implement a research plan to help guide you through finding the resources that contain the law that answers your legal research questions. Throughout the series of presentations, we'll discuss the process and the location of these different resources and how to use and find them, and eventually how to develop an effective research plan. Earlier we said that legal research is the process of looking for all of the legal authority that answers the legal issues presented by our legal problem. But that raises the question of what is legal authority? What is the authority that we need to search for? There are actually various kinds of authority, and legal researchers need to understand all of them in order to properly find authority to answer those legal issues. The first type of authority is primary and secondary authority. Primary authority is that law that is issued by a governing body or its officials in their lawmaking capacity. So this would be judicial opinions or cases written by judges, statutes enacted by legislatures, regulations promulgated by administrative agencies. Of course, the Constitution itself is a type of primary authority. This authority is primary because we, in our form of government, empower these entities to make law for us that will bind us as citizens. The other kind of authority, though, is secondary authority. And secondary authority is descriptions of or commentary about the primary authority. So this might be a law review article discussing a statutory scheme governing corporate officers and whether or not that scheme is a good one and how it could be changed and what it actually is. Or it could be a legal encyclopedia article about a topic in negligence or torts or corporate law that describes what the area of law is, what are the key cases and key statutes. It could be practice treatise articles, and it could be books about the law, nutshells, anything that provides commentary about the primary authority. This is secondary authority. But there's another kind of authority as well, and this is binding and persuasive authority. So binding authority is that law that governing bodies within an appropriate jurisdiction is required to follow. Well, what this means is that they're required to follow the primary authority, the primary law, the cases, the statutes, regulations, etc. That's binding, or also known as mandatory authority. Now, it turns out they don't always have to follow all of it. It depends where it comes out of the jurisdiction. We'll talk about that in just a minute. The other kind of authority is persuasive authority, and that's law that governing bodies are not required to follow. So this would be primary authority from a different jurisdiction, and it would be secondary authority. So all secondary authority is persuasive authority because none of it is issued by a governing body or an official in his or her official capacity. So it's always persuasive authority. But what about the binding authority? Why is it that sometimes it is why is it sometimes primary authority is binding and sometimes it is not? So to understand why some primary authority is binding and sometimes it is persuasive, let's look at this diagram of state court systems. So in this diagram we have a state 1 system and state 2 system, each with a Supreme Court, an intermediate appellate court, and also a trial court. So the rule is that state case law issued by the Supreme Court is binding on the intermediate court and the trial court within that state. As also in state 2, the cases issued by the Supreme Court in state 2 are binding on the courts, the intermediate appellate court and state trial court in state 2. But they're not binding on state 2's cases, are not binding on state 1, and state 1's cases are not binding on state 2. It's merely persuasive authority. So there we have primary authority, a case, which is persuasive authority in a state that didn't actually issue that that case opinion. So now that we have an understanding of authority, I think we can go back and refine our definition of what legal research is. It is the search for binding primary authority that resolves the legal issues being researched. Along the way of finding that binding primary authority, we will uncover non-binding primary authority as well as secondary authority, all of which will help us understand the law in the particular area and how that law applies to our particular legal situation. So that brings me to the themes of legal research. And legal publishers know what it is that we now know, that researchers need to find all the law that's relevant to the legal problem at hand, all of the authority that's relevant to the legal problem at hand. And so there are various ways in which law is published that we can take advantage of to simplify our research process and provide us with confidence that we're finding everything. These themes are chronological and topical publication, finding aids, updating methods, and connectivity. So chronological publication is that when law is produced, it is published in the order in which it was produced. It's published chronologically. So an example of this would be a slip law or a session law that's issued by a legislative body. As soon as it is enacted, it can be published to their website, and then at the end of the legislative session, these slip laws are collected and published in the session law volumes, and they're published in the order in which they were enacted. Cases too really have a form of chronological publication. When the case is initially decided, it's published to the court's website typically, and then it's sent to publishers who publish it as part of an advance sheet. And then finally they're put into bound case reporters in print or put into a database online. But in the case of the print reporters, the case print reporters, they're published in the order in which the case was decided. There's no effort made in chronological publications really to organize the law that is produced at that time topically. The advantage of chronological publication, it's very fast. As soon as the law is ready to go, it can be published and made available to researchers. The disadvantage of it, though, is that it's hard to find related law. Again, we'd like to find all the law that's relevant on a particular topic. Chronological publications really are not designed to do that. The solution to that problem is topical publication. So topical publication are subject organizations of law. So in this kind of publication, all of the law on a particular topic is gathered and published together. A good example of that is a statutory code. In a statutory code, the body of statutory law is divided into subjects, and all of the statutes that are in force at the time the code is actually created are put into the appropriate subject area. This is also true for regulatory codes. This makes it easy for legal researchers to find all of the law on a particular topic. So this is really, topical publication tools are really better for research. Another theme of legal publishing is finding aids or using finding aids. So a finding aid is anything that helps us find primary or secondary authority. It in and of itself is not authority of any kind. It's just a pointer, a redirect. Probably the finding aid that we're most familiar with is an index. An index is an intellectual abstraction of the contents of a book or of materials of some kind. It's the indexer is giving us ways to think about the materials inside the text itself. And using keywords, we look in the index and that redirects us to the part of the book or the series of books that contain the discussion of the item we're looking for. The other kinds of finding aids, though, tables. Certainly we're familiar with the table of contents. This is a great tool to use if we want to skim what is involved, what is included in a particular book. It's great for doing statutory research. It helps us establish context for where we are in the code. And it is a very useful finding aid. There are other kinds of tables besides tables of contents or tables of laws, statutes, and cases that point us. You can use these to look up a case or a statute, and it points us to the location within the book or the resource where it's discussed. There are also conversion and comparative tables that help us to help us determine where new statutes were published from an old statutory code or vice versa. Of course, a user guide is a kind of a finding aid. It helps us use the resource. It might give us some tips on how to search within the resource. Another theme of legal publishing is updating methods. It is extremely important in law to update your research, and it should be part of your legal process all the time to make sure that you're using using valid statements of the law. There are a couple different ways that publishers provide us to do that. One method is to look within the resource itself. If in print publication, if you're using a hardbound book, typically there's a pocket part supplement tucked away in the back of the book that updates the hardbound volume. If you're using a loose leaf publication, they'll simply update loose leaf pages. You look at the pages themselves to determine the date in which it was last updated. And there also might be a cover page in the volume that tells you what was last updated. They can also update hardbound volumes with softbound supplements. So you need to look for all of those when you're doing your print research. More likely you're doing a lot more online research. If that's the case, what you want to do there is either look for that little information bubble. It's typically a little bubble with an I in it next to the title of a resource that'll tell you information about the currency and coverage of the online resource. Or you might see a link toward the resource up toward the top or bottom of the item you're looking at online. It says currency or maybe currentness. This is typically how it's done in statutes. That indicates the last session law which the code section was checked for currentness. Publishers also may just publish a separate resource that acts as a updater. The best example of this is a citator like Shepard's or KeyCite. This updates case law or statutory law and tells us whether or not that law is good law, and also directs us to new or additional cases. Always want to check KeyCite and Shepard's. Another theme of legal publishing, though, is connectivity. And so here what we're taking advantage of is the fact that authority points to other authority. Resources point to other resources. So if you're using an annotated code, a statutory code, it may have cross-references to other statutes that apply to the code section you're researching. It'll likely also have cross-references to secondary authority that are written about that statutory scheme or that code section that help us understand what that code section is saying. They will certainly have cases, annotations to cases, if cases have litigated that code section before. when you're doing online research in Lexis or Westlaw, you'll see often something like a related content panel. And what this does is that it takes what your research results were and it provides you the cases or statutes you're looking at, but then it provides additional resources that are relevant, or the system determines are relevant to your research query, and directs you over to secondary authority, law review articles or treatises to help you get the big picture and all of the authority that's relevant to your legal problem. So this brings us to the big picture, if you will, of legal research. And simply this, given the connectivity, given our need to find all of the authority that applies to a particular legal problem, we can think of the legal research universe in this diagram, where we have certain starting points, which here are represented in green. It can be a keyword and index, it can be a citation, it can be a topic and key number, something we'll look at in a later research presentation. But once we have an entry point into the legal research system, we can then use the connections between the various publications of authority to find all of the authority that is relevant to our problem. So for example, if we have a keyword, we can use the index in the back of a secondary authority or in a separate secondary finding aid publication. That'll get us to an article about some area of law. That article itself will contain citations to primary authority, to cases and statutes. We can then use those to find the appropriate statute or find the cases that are relevant, and we can read those statutes and read those cases. We can then use the topic and key number system to find additional cases that cite to and are relevant to that particular case, or we can use a citator to make sure that case is good law and find additional cases from there. So if we work with the connections that are provided through the various legal research resources, we can then go and solve the big picture of legal research, which is to find all of the legal authority that applies to our problem. So this is the first of the lectures of presentations on Introduction to Legal Research. The rest of the presentations will delve more deeply into these different content areas, providing research methods and information to make you a better and a more efficient researcher. Thank you.